Okay, it's 2:52. We'll go ahead and get started again. It looks like we've exhausted the governors, and so now it's time for public comment. Recognize Ms. Hawkins, followed by Mr. McPherson, followed by Mr. Couch, followed by Ms. Limerick, and then Governor Jarman.
Thank you. Once again, on behalf of the Family Law Section, we oppose this resolution. We oppose the Board of Governors taking any position at this time. We want to see other options considered that may achieve a competent group of lawyers, but isn't improperly burdensome. The Board of Governors has not considered any other options, but the task force is doing so, and we should not be prematurely getting involved in this organization taking a position on a small aspect of their considerations. There was a comment earlier that the members of the bar overwhelmingly support this resolution. And frankly, I find it hard to believe that 30,000 members or more read the 800 pages of the BOG materials that were released less than 1 week ago and have since then expressed support for this specific resolution. I don't believe it. Members don't read the BOG materials. It is a very small number of people that do. I do think that there have been a number of comments on listservs and other places supporting a bar exam. But I believe that the vast majority, if not all of them, are comments saying they support a bar exam instead of diploma privilege. That is what caused the big ruckus last year. And if those members think there are only two options, then the Board of Governors needs to focus on educating them down the road when the task force presents other options for consideration. One of the first comments I heard when this discussion started was that the minority bar associations oppose this resolution and the timing of it, but their opinions are not binding on the Board of Governors. And it is true, they are not binding on the Board of Governors. But how do you think that kind of comment will play the next time that Governor Angevin goes to a minority bar leaders meeting and reports that's what this Board of Governors said? Do you think the minority bar associations will continue to comment to this bar association if their comments are dismissed so cavalierly? How do you think the diversity committee feels about those kind of comments? The minority bar associations, the diversity committee, others who care about those issues are not others. They are our members. They are some of us. It is not enough to say, oh, we let them speak, but we don't have to actually listen. We can let them speak, but they can speak to someone else, but we don't have to take their opinions into account. What is the work that this organization's been doing for the last year if that is the present position of this Board of Governors? Frankly, I'm just appalled by some of those kind of comments. You heard from Governor Angevin and former Governor Jarman that the Board of Governors needs to take into account the opinions of the minority bar associations and others who want to have a less discriminatory process. And again, they begged you. What is the point of the work learning about equity issues over the past year if it isn't taken into account on the one issue on your agenda over this 2 days in which equity issues play a prominent role? So I would urge you to oppose this resolution and oppose the Board of Governors taking any position at this time. And pay more attention to the comments being made by minority bar associations and others who are primarily focused on underserved members, underserved communities. Remember the things you have learned, hopefully, over the past year. Thank you.
Thank you, Ms. Hawkins. And to Ms. Hawkins' point, we mentioned last meeting that we were working to meet with the MBAs virtually and or in person. And Executive Director Nevitt and I are going to try to put together a meeting with the MBAs as soon as next month. So there will be an opportunity to talk with the MBAs directly about this and other issues shortly. So the Board of Governors may want to take that into consideration in considering this motion. Mr. McPherson.
I guat start in a place I hadn't expected to, but having listened to Nancy, I guess I'll at least stand up a little bit for what I heard earlier today. I thought that the comment was not something that cavalierly dismissed comments of minority bar associations or anybody else. I thought that the way I heard the comment was that if anyone disagrees with what the Board of Governors does, they certainly can make a direct comments to anybody they want, including the Supreme Court or the task force or anybody else. So I think that was a little bit misdirected there. But I'd like to focus on a couple of things here and finish with what I think is the main issue. If you look at the what the resolution actually says, and Governor Knight already went through this, they think that some bar exams should be required and the diploma privilege is not a good alternative. It discourages, it doesn't say never, which certainly takes into account last year. Taking those two things together, I think that they are tied. The way I look at it is that the bar examination is one of those minimum standards, or at least an examination of some kind is a minimum standard to be licensed as an attorney in the state of Washington. And Governor Stevens made a big comment about how you could never, you must have an exam no matter what, no matter whether it happens. Actually, I think that's true. I think that there has to be something, I don't know if it's in writing, if it's oral, if it's in front of a panel of 5 people, if it takes 2 days, if it takes 15 minutes, something has to be created as an examination of some type in order to become an attorney. And I think that the vast majority of both attorneys and the public would agree with that. And they can't imagine another way that you could legitimately become a lawyer, particularly if you have to learn local law and things like that. Now, it's an example of like the black swan. I can't imagine that there is a way to become an attorney that won't require at least some form of examination. If I'm proved wrong, if the black swan comes up from Australia or someplace, I'm proven wrong. That's fine. But I think that some type of examination is going to be required to become licensed as an attorney. The second part about the diploma privilege was already hit upon by Governor Knight about, you don't want to accede to another organization to create competent attorneys in the form of a school. And B, just going to a law school doesn't give you potentially, if you went to law school in Kansas or Nebraska or Florida or New York, you got to learn about Washington law. Washington law is different. I had to learn Washington law. I passed the Hawaii bar in 1977. When I came up to Washington in 1979, I had no idea what community property was. I'd never heard of it. So you're going to have to get local law. So you can't use the diploma privilege by itself, I believe, maybe mostly. In fact, you could even have it so that, hey, if you come from an accredited law school, you only have to take a half-a-day exam about Washington law or a day exam about Washington law. There's other ways that this task force, I'm sure, will look into. Uh, and but really the main part, I thought when I first saw this resolution before this entire controversy arose, was number 3, which is, hey, the bar, and it is, as recognized by the Supreme Court, needs to be re-examined. It doesn't seem to do what it's supposed to do. And I know that the next speaker that we hear from is going to tell us about the historical depravity of those who created bar exams in order to keep Black and brown people out of the legal profession for decades and decades and decades. That was one of the primary reasons for a bar exam. That's horrible. It should not have been, and it should never, ever be. And I think that the vast majority of people today, and particularly Washington lawyers, will say, we don't want that. We want our exams to be legitimate. We want them to be non-discriminatory. We want to make accommodations. I mean, I remember when we had to accommodate for people typing the answers to the exam. You know, they had to have a special room, you know. I mean, this was back in the 70s, but when they still had manual typewriters. So yes, that was a horrible thing. And the exam is starting from a bad spot. It's got to be changed. Recognized how bad it's been, move forward. And I suspect that's one of the reasons why this current task force is going to take so long. I think it's, well, relatively long, until the next December in 22. So that was what I considered to be the main part of this. And instead, it's turned into something else. And I do understand the disconnect between saying, you know, we support the WBLTF or TF, WBLTF. I don't know if we'll ever get used to that one, but, and then say, but it's got to have an exam, and but it shouldn't have diploma privilege. Again, Black Swan, some kind of exam. Diplomas, you can't have that all by itself. That's not enough. But really, this is what I wanted to come down to, which is why now? And really, I was at the, of course, I've been at these meetings for 20 years, but I was at the last meeting. I heard some bristling that said, hey, you guys are not, you didn't even talk to us as the MBAs before you brought this up. That's wrong. Don't talk for us. Don't talk for us. We can talk for ourselves. I thought that was a very legitimate comment. And then it was like, why don't you wait until the task force is done? Well, maybe not till done, at least until it's started. Why now? And that's why it's become, I believe, such a tense topic for these last 2 meetings. And I got some reactions to that. First off, and it's both good and bad. The bell has been rung now. We can't deny that. You got to look yourself in the mirror and say, this has now become a topic. So what are you going to do with it? And it's for 2 reasons. One is because of this whole pandemic, everybody's tense. We had the bar canceled last year. We had the diploma privilege. A lot of people got really upset about that. And much of it, frankly, was, hey, I had to take an exam. How come they didn't have to take an exam? Well, some people are going to say, well, the exam was just a bar to jump. You had the money, you had the time, you had the benefits that nobody else can do. And you happen to get there, and now you're keeping everybody else out. That's legitimate arguments, very legitimate. That's one reason why it's become up. And the second one is because last meeting, the last 2 months, when it hit the table and then it would spread out to the bar, we finally got what I've been trying to get for the last 20 years is, how do you get your members interested in something? Get the word out so that they react to it. You did a real good job with that, didn't you? Okay, so now you got people bristled. So what are you going to do about it? If you don't pass this resolution, I'll tell you, there's going to be a lot of people that say, oh, so you don't think we should have a bar exam? Really? Because they're not going to read it that carefully. They weren't at all these meetings. They don't understand the comments that have been made. There will be a group that'll be uninformed, and that's the decision they'll make. On the other hand, if you do pass the resolution, there's a whole bunch of people who are going to say, see, we told you, you're talking for us. You know, you're trying to jump in before the task force even has a way to get started, and you're undermining the process and you don't listen to us. So you're obviously in these two camps. So what are you going to do about it? Well, frankly, I don't know. My initial reaction was, this isn't so bad. It is a point in time. It certainly says we should change the bar exam. I firmly believe that there should be some kind of exam until that black swan shows up. I think there's going to be an exam. And I don't like diploma privilege because by itself, I think maybe partially. And I also think that nobody's mentioned this. This is not a bar exam task force. This is a licensure task force. And I hope that they look into things like, should we have a solicitor and barrister kind of practice in Washington? If you're going to go to trial, do you know how many kids I've tried cases with that I had to teach them how to try a case? My opposing counsel? It's ridiculous. They don't know how to try a case. Maybe we should have something similar to the apprenticeship or intern or a medical rotation kind of practice or you have to have a special kind of license in order to do a special thing. I hope they look into that. Estate planning, family law, whatever it is, maybe we'll have tiny little bar exams. You got to take each one if you want to take that practice. But I got to tell you, and it's maybe inadvertent, but you guys have gotten yourself in a big mess right now. But you have to recognize where you are and what both your MBA underrepresented people are going to think about what you do today and what others in the bar that are now have woken up and say, you're really going to say that you don't have to have an exam in order to do this? And then we'll have to educate them. The last thing I'll mention is this: public perception. I don't think anybody's mentioned that. Maybe they did and I was asleep. But, that's one of the things that the task force is going to have to deal with is if we change the way people become lawyers, we've got to make sure that the public trusts what we're doing and that you're not going to say, okay, I only going to go to Jim because, he passed the bar, 40 years ago or 43 years ago. And I don't even remember, 80% of what I'd learned back then is gone. Frankly, you guys know that. But the public thinks, if somebody's got to be licensed. And if I'm going to go to this old guy because he passed a bar, and I'm not going to go to this young person because they didn't have to take a bar, that's not good for the public either. So I guess I'll say good luck. I think if it was me, I would probably pass the resolution and try to explain to the MBA people that this is an exam. We're going to listen to everything you have to say to make this so that you can make it fair. We're going to set up a amount of money that the bar is going to set aside that if you qualify, we will pay for you to get to take the courses in order to pass the bar. There's going to be lots of ways that we can assist those who are having difficulty entering the profession. But I do think that an exam is going to be required of some kind. Diploma privilege is not a good idea. The three things in the resolution make sense to me.
Thanks, Mr. McPherson. Mr. Couch.
Thank you. I'm actually going to skip the history lesson today. I thought I'd try a different tactic this time. I'm happy to see that there appears to be a growing shift among you to oppose this resolution, but I've heard a number of you in support of it argue that we need to speak now and that it's okay. The Board of Governors can change its opinion as information becomes available. So I wanted to take a minute to remind you that what the Board of Governors says matters. What you do matters. Our members who made the difficult decision to accept diploma privilege now face discrimination in our profession. And intended or not, that discrimination was validated and supported by the BOG's decision to publicly oppose the Supreme Court rather than standing behind its new members. Like it or not, the Supreme Court made its decision and the BOG found itself on the wrong side of history last year. And this resolution, I think, continues that harm. I believe deeply in this institution, but after the events of last year, I regret to inform you that most new members I speak to do not share my belief. Although this resolution has no binding impact on the task force, it doesn't change anything. Today, you are taking a vote to publicly support a system that the task force and the Supreme Court may reject. And it is a system that I would challenge any of you to find support for in history or data. And how many of you over this past month have taken the time to study the bar exam deeply? How many of you read a study of the relationship between bar admissions and data and subsequent lawyer discipline from LSAC, or Jeffrey Kinsler's article in the St. John's Law Review, or Robert Anderson's article in the Georgetown Journal of Legal Ethics, or Kyle Rozima's Does the Bar Exam Protect the Public? Have we done the work to do this? It's not just about how fast or slow you act. It's about whether you have done the work to be able to take a stand meaningfully. You say that the bar exam protects the public, but we have had and currently have diploma privilege in this country, and the disaster you describe has never come to pass. The president of the NCBE, that woman who oversees this entire process, who you're putting your faith in when you support the bar exam, never took the bar exam. You say that you believe the bar exam is necessary, but all of us are here today because of a bar exam in one form or another that the creators of which have admitted was deeply flawed and racially discriminatory. If an effective bar exam is necessary to validate our profession and protect the public, then none of us have the right to be here today. And I know that isn't easy to accept. For a lot of us, myself included, passing the bar exam is an accomplishment we take great pride in, and rightfully so. But just because we are right to take pride in accomplishment does not mean that the exam itself was right. If you cannot imagine a world without a bar exam, I'll suggest that that may be less of a praise of an exam and more an indictment of your own imagination. I graduated from America's third oldest college without taking a single test. And to this day, I do not know a single grade that I got in those 4 years. And yet I went to a top 25 law school, and here I am before you. Married, by the way, to a woman who teaches at a school without tests. So before you vote today, I want you to ask yourselves what you hope to accomplish with this resolution. What's the point? Would you like the task force to know that a slim majority of the current Board of Governors likes a bar exam? Great, I can email them now. The meetings are open. You can all come. Anyone is invited to be part of that and share their feelings. But if you vote in favor of this resolution, be warned that you may find yourselves on the wrong side of history, entrenching a system that was designed to exclude people of color and that continues to effectively do so today. Now, despite you all saying you want to make sure that there is no discriminatory impact, I understand that it's hard to push off in the bar exam too hard. I'm not asking you to solve the racial problems in our profession. I'm not even asking you to take a stand against those systems that perpetuate that discrimination. All I ask is that you step aside and let the body that has been convened to investigate, research, and address those issues do its work before you commit this institution to a position you may regret. And the last thing I'll say is this. I understand what you have heard from your membership. I've read every single comment. But the question you have to ask is not just what are their opinions, but what basis do they have for their opinions in data and history? True leadership lies in the strength to do what is right, even when it is unpopular. The history of popular opinion in America is a history of discrimination and fighting to maintain an unjust status quo at every single step of the way. But the history of progress is a history of leaders willing to do what is right, despite popular opinion. And I'm not even asking you to do what's right. I'm asking you to do nothing, at least for now. Thank you.
Thank you, Mr. Couch. Ms. Limerick.
Thank you, Mr. President. Well, I want to supplement my earlier comments that I had offered during the earlier comment period and also restate my opposition to the proposed resolution regarding the bar exam. Because many of the materials that were submitted for your review were not included in the meeting materials, I want to share with you at least one of those with you now. It was dated April 15th, 2021. Dear WSBA Board of Governors, the undersigned Minority Bar Associations of Washington oppose the adoption of the resolution in support of a bar exam to ensure a competent, ethical, and diverse legal profession, the proposed resolution, and echo the concerns raised in the April 13th, 2021 letter from the Washington State Bar Association's Diversity Committee. The proposed resolution displaces the forthcoming recommendation of the Washington Bar Licensure Task Force, the task force, which was created under the authority of the Washington State Supreme Court, order number 25700 B649, entered November 20th, 2020. The task force was formed in part to examine alternative licensure methods, consider the need for alternatives to the current bar exam, and analyze those potential alternatives while assessing disproportionate impacts on examinees of color and first-generation examinees. This is cited to the Strategic Initiative Charter, Washington Bar Licensure Task Force, paragraph 4. The proposed resolution provides that the WSBA supports the continued requirement of passing a bar exam before admission and discourages diploma privilege as an alternative to a bar exam. These provisions invade the task force's charter. They are premature and unsupported by the type of examinations, considerations, and assessments that should undergird conclusions about the efficacy of the Washington State Bar Exam and related requirements for licensing competent lawyers, for which the task force was formed for the express purpose of conducting. The undersigned minority bar associations ask that the proposed resolution be rejected and that the Washington State Supreme Court make a determination about the requirement of passing a bar exam before admission only upon review of the task force's recommendation, after it has been provided in due course. Respectfully submitted by the Washington Women Lawyers, the Filipino Lawyers of Washington, and the LGBTQ+ Bar Association of Washington. Now, I must point out that there has been no credible, persuasive explanation offered yet as to why members of the board are insistent on issuing a resolution at this time. What I've heard is that we must speak now. When we don't speak, we're met with failure, which causes me to wonder, what failure are you concerned about here? It seems that the goal is to take a position and purport it to be that of the general members. Additionally, I want to challenge the suggestion that effective efforts were made to involve all members and MBAs and seek their input. This topic of WSBA's proposed resolution on the bar exam was introduced at the joint MBA spring meeting on March 19th. Please take note, that meeting was less than 30 days ago. And yet the MBA leaders did what they could in the very short time provided. Given the timing, it wasn't possible for more than just a small handful to gather and discuss the matter collectively. But even so, they were able to consider the matter, prepare statements, and expedite the board approval processes in order to try to have our voices heard. And as a result, our members were made aware of this issue and encouraged to submit comments to bar leaders at WSBA.org and to their respective regional governors. So this is why the influx of emails in your inboxes occurred at such a late date. I'll add that the process for submitting comments was not clearly communicated. A deadline for providing comments was not specified on the WSBA website. And I have to say, I take great offense to a comment that was made earlier when the board was taking a break for lunch, that people were given time to submit comments. So if they didn't get it in, then that's just tough. Please take a moment to recognize that the comment reflects an example of a self-centered communication style, one that claims to seek input from the general membership, but the approach is that of a notification rather than an invitation for member input. If there is a strict procedure for submitting comments, then in the future it should be made clear and publicly known. Also, Governor Knight reports that there is overwhelming support for a bar exam in some form. But it was also mentioned that there were something like 100 new comments that were submitted that were not included in today's meeting materials. I'm certain that the governors have not had the opportunity to review those comments from their members, so those voices are not being considered in today's vote. Lastly, the comments made today reinforce the importance of ensuring that the minority bar associations are given the opportunity to have representatives on the bar licensure task force as members with full voting rights. Our organizations and membership are directly impacted by the current bar exam and licensure requirements. Our representatives should have an equal voice at the table. Our experience and concerns should be given full weight and consequence beyond mere consultative value. So it's unclear to me right now whether the identified MBA representatives that currently have full voting rights on the task force. But if they don't, then that should probably be changed. This resolution is premature. This board does not have the basis for an informed opinion at this time. Staking a position on a continued bar exam requirement is unnecessary. And I respectfully ask that you vote no on the resolution and allow the Supreme Court's task force to perform its research, analysis, and develop its recommendations. Thank you for allowing me this time to comment.
Thank you, Ms. Limerick. Governor Jarman.
Thank you. I also will begin by reading a letter from one of our minority bar associations dated April 15th, 2021. Dear Board of Governors, the Lauren Miller Bar Association opposes the bar resolution proposed by Governors Russell Knight and Hunter Abel. Consideration of the resolution at this time is premature. As you are aware, our Washington State Supreme Court recently structured a task force that is charged with evaluating and assessing the requirement for individuals to take the bar exam to become a licensed attorney in our state. This matter is of grave importance to our organization because the bar exam has directly impacted our members. The bar exam is but one barrier in the long-standing history of things that have obstructed the path to the legal profession for minority students. The most prudent thing to do at this juncture is to let the task force complete its work, make its recommendations, and then decide on whether to support the traditional bar licensure requirement. The Washington State Bar Association bylaws state it strives to promote an effective legal system accessible to all and will promote diversity and equality in the courts and legal profession. As a governing body of the WSBA, the Board of Governors has great power as it determines the general policies of the bar. If you truly stand by the words as stated in the WSBA's bylaws, then your actions must match your words. Simple and plain. We ask that the proposed resolution be rejected. What is this body's obligation to account for the voices of its minority membership on a matter that directly impacts them? Their access, our access to participation in this very process. It's somewhat shocking and offensive that there is a suggestion that this body is being silenced. This body is not being silenced. This body is not being marginalized. You are asked to be responsible to and considerate of all of your membership, to include the voices of your minority members and organizations. These organizations represent hundreds of members, but even in our hundreds of members, we are still disproportionately underrepresented in this legal field and at this table. Why are we so uncomfortable? Or more importantly, why is this board so uncomfortable with the suggestion that yes, it's possible that our examination process instituted hundreds of years ago or some years ago might actually have some discriminatory impact? That's something that we need to reconcile with. Here, you have an opportunity to look at that in the finely crafted task force. And what cannot go unnoticed is that this task force is very particular about saying all of the different elements and areas of inquiry it's going to make. It's going to review past studies. It's going to study and report on the history of the bar exam, both nationally and within the state of Washington, particularly with regard to the purpose of the bar exam at its inception. It's going to compare the bar exam passage rates with other states. And if such data exists, compare those passage rates with examinees of color and first-generation examinees. It is simply ironic and perplexing and quite sad that here we have before us an opportunity to look at something that impacts your minority membership And you are taking the position that you are not going to listen to them on the very issue that impacts them. And I submit to you that this is not an issue that arose in minority communities or in minority legal organizations just on the basis of the pandemic. This is an issue that we have long been grappling with and long been asking this bar association to take a look at. And now there is the opportunity to do so. Lastly, I would just say to you, I am mindful of the Supreme Court's letter that continues to resonate, or at least I believe it should. Finally, as individuals, we must recognize that systemic racial injustice is not an omnipresent specter that will inevitably persist. It is the collective product of each of our individual actions, every action, every day. It is only by carefully reflecting on our actions, taking individual responsibility for them, and constantly striving for better that we can address the shameful legacy we inherit. We call on every member of our legal community to reflect on this moment and ask ourselves how we may work together to eradicate racism. In the particular context of the legal profession, in the particular context of striving to make a deep dive inquiry into disproportionality, this is now your opportunity to do that with a task force. This is your opportunity. Yes, you have a voice. It is a powerful one. So the question is how you're going to use that voice in reflection upon the commitments that you've made to minority membership. How are you going to use that voice to be responsive to the call of action, looking at these issues that impact the path of diverse populations to the legal system? I submit to you that this resolution does not advance the objectives intended. And in fact, it's to the contrary. And you have a moment right now to say to all of the membership and all of the organizations that you've heard from, to include the minority bar associations in particular, that you've not only listened, but you've heard, and now you're ready to take action based upon that.
Thank you, Governor Jarman. All right, I don't see any other hands. Any additional comments from, Executive Director Nevin?
I have a clarification before the board moves to a vote on the amendment. In terms of resources, I just want to understand, is this something, do you have a number in mind for, what would be available to work with experts? Is this something to build into the next year's budget? I just wanted a clarification on that.
Governor Becky?
Yeah, my expectation is that you and the staff would come back with a proposal that could then be a budget amendment this year. But it's going to require some staff work to identify the professionals, the academics that you want to work with. So you'll come back with that. Tell us why they're the pros from Dover that we should be working with to, find a form of testing that is fair and equitable and non-discriminatory. And then we'll do a budget amendment.
Hey, Governor Stevens.
So I was looking at the amendment language, and I just want to understand what and who we mean by the WSBA. And I asked this question because with your ad, again, commits to working with testing and academic professionals to accomplish this review. I am now again asking, well, wait a minute. Isn't this a part of the review that's being done by this Supreme Court created and led task force? So, as opposed to asking questions, we're now making a commitment, but we're making a commitment also prior to whatever the task force decides. So again, I think we're getting into the business of the task force with the Supreme Court in the lead. And I understand you want to make this palatable, but I'm just trying to understand what WISBA are we talking about? And how does this fit within the context of the task force? Because I certainly don't want us now going off to do stuff while the task force is still doing its work. You know, Mr. President, if I could just add a little bit more, you know, there are times I think we have resolutions and proposals so that we can just do stuff, just do something. And I guess that's what troubles me the most. We're trying to do stuff and fix stuff before the Supreme Court led task force has done any of its work, as opposed to, you know, we could actually write a letter raising a number of our questions, but we're trying to even here decide what will be done and how it will be done. And I think that's, again, putting the cart before the horse. I think it's one thing to raise whatever our questions and concerns are. I think it's another thing to just keep trying to weigh in. This is what we're not going to do. This is what we want to do, et cetera, before the task force does its work. I actually also don't think this is respectful of the leadership of the court on this subject. And I would rather them lead and we give our input and we give our offers of support, but not start trying to take actions before they're done with their work.
Thank you, Governor Stevens. Executive Director Nevitt.
Yes, thank you for giving me a chance to speak again. I think Governor Stevens gave voice to some of the discomfort that I'm feeling about how to carry out this amendment, and worried about getting at cross purposes with what the task force is doing. Or, I mean, I think we should, and I think we have, through both Chief Communications Officer Nagowski and myself, expressed our willingness to be supportive. And I certainly would be appreciative to have the budget to go behind those words. But I am a little worried about having a mandate that we have to carry out without knowing if it's going to be consistent with what the task force is seeking from us.
Thank you, Executive Director Nevitt. Governor Grabicki.
Well, first, WSBA refers to the organization of which we are the governing body. There's nobody on the task force that has grounded expertise in developing appropriate testing. And they don't have a budget to do that. This is going to cost some money. I represented a company that developed and administered tests for nursing students and nursing graduates. It was eventually sold. And it worked very closely with the big academic testing institute at Kansas University, which is one of the foremost academic testing development organizations around. And in order to determine what's wrong with the current exam, and in order to determine what is an appropriate exam that meets the criteria that we all want, you're going to have to engage some academic professionals who know how to design these things and know how to critique them. It's not enough just to moan and say, "Jay, this isn't fair." You've got to have a solution. We're going to provide part of that solution. This will be supportive of the task force. We will share all of this with the task force. We're not going for any predetermined conclusion. This is a very constructive step. So I think we should go to a vote, and I urge everybody to vote for this. I think this is a very reasonable approach. I think it's a very thoughtful approach. It's a constructive approach, and it also happens to reflect the position of the majority of our members.
Mr. President?
Yes, Governor Stevens.
So, PJ, are you moving the question? You gave an opinion, I just trying to understand.
No, I'm not going to do that. If somebody else wants to say something, I'm not trying to cut them off.
Okay.
I will get this done, but if somebody has something to say that hasn't been said yet, have at it.
Okay. I was just kind of clarify when you said you wanted to go to a vote.
All right, I'm seeing no more governor's hands. Ms. Hawkins, you had one opportunity before. I'll give you another opportunity because we are getting close to, or we're now actually over our time, but I'll ask you to be brief in your comment. Ms. Hawkins.
I will be brief. Thank you. I wanted to just make sure that the group knew that the family law section has not said they want diploma privilege instead of a bar exam or has picked any option in particular. They want all the alternatives analyzed. And that's exactly what the task force is supposed to do. And I'm reading from their, the memorandum. The task force will examine blank, 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 consider the need for alternatives to the current bar exam and analyze those potential alternatives. You know, in our executive committee meeting, we talked about internships. We talked about a number of different possibilities. This task force is going to analyze them. This task force is not going to moan about discrimination, nor did our section, nor the MBAs. People want alternatives. They want them well thought out. I have faith in the Supreme Court and the other distinguished people on the task force, that they will handle this in the same way that the structure task force did, which is to bring in people to provide information, to investigate. We don't have to do anything at this stage for there to be information for the task force to consider. That's their job. I don't think that we should be spending money now to analyze a bar exam option when there are lots of other alternatives still to be considered.
Thank you, Ms. Hawkins. All right, I understand we have a motion. Governor Grabicki, I asked you to restate it or get ready to restate it. Perhaps you can do that now, and then we can do a roll call vote.
Tara, did you forward the email from Russell to everybody so they've got it in front of them?
I did not. I thought Russell sent it to everyone, but let me double check.
I attempted to send it to everyone. I replied to the email that was the invitation to this meeting.
It looks like it was sent to everyone. However, I can screen share it or read it or.
Yeah, why don't you screen share it? That's probably the most appropriate thing.
Okay. Give me a moment.
So the amendatory language is down towards the bottom. It's the last sentence in paragraph 3. The WSBA commits to working with testing and academic professionals to accomplish this review. And then a new paragraph 4, WSBA authorizes sections and committees to comment task force on this issue without prior authorization or review by the board or the legislative committee.
All right. Everybody understand the motion and remind me who seconded? Was that Governor Abel?
I think so.
All right. We have a motion seconded. I'm not seeing any further hands. I'll proceed forward with a roll call vote. Governor Abel.
Aye.
Governor Boyd.
No.
Governor Grabicki.
Aye.
Governor Stevens.
No.
Governor Pertzer.
Aye.
Governor Peterson.
I'm going to abstain. I just don't know what the right answer is here.
Governor McBride.
Aye.
Governor Angeville.
No.
Governor Dresden.
No.
Governor Clark. Governor Knight.
Aye.
Governor Higginson.
Aye.
Governor Kang. Governor Williams-Ruth.
I didn't hear Governor Clark's vote. What did you get, President Schiketti?
Governor Clark voted no. So I have 5 noes, 6 yays, 1 abstention. Is that what you have, Executive Director Nevitz?
Yes.
All right, motion carries. Thank you, everyone, for all of that dialogue and discussion. And thank you to the members of the public also who devoted significant time and effort to thinking about this issue and sharing your thoughts with us.